When artists and music producers sign up to be on music distribution platforms, you sign a contract. Is there something funny going on in these terms that you guys don't know about that you are signing? Is it time to expose DistroKid? So as you guys have been following along with TuneCore, we have been in it. And a big part of what we've talked about in regards to this dispute that we've had with them are their terms of service. And their terms of service are problematic. And kind of our call to action and what we've been talking about is that we don't think that it is appropriate for any middleman company like a music distributor to take royalties for any reason that they are not entitled to. So now today, we're going to be looking at DistroKid. As an artist myself, I have distributed my music through pretty much every music distributor out there, so I have some personal experiences that I can point to. But today, we are sticking within the four corners of their terms of use. They have a couple different documents on their website. So there's a privacy policy, there are the terms, and then there's the distribution agreement. Now, in the TuneCore situation, the terms of service was the distribution agreement, okay? Different titles, same thing. In the DistroKid situation here, the distribution agreement are the terms of service that you are agreeing to. So let's take a peek. And what I want to do, I've been through this already, so I'm not going to bore you by going through all 13 pages line by line, but I want to point out and just see, is this top music attorney approved? Is this something that we can agree to? Is there something funny going on in these terms that you guys don't know about that you are signing? And that's my problem. When artists and music producers sign up to be on music distribution platforms, you sign a contract. And I know you know that because you click the "you accept our terms of service," but I don't think a lot of us actually read them. So I'm going to do the hard work for you. All right, and we're going to go through it right now. So what I've done is I've taken the current terms of service. This is their distribution agreement as of today. And this is the June 8th, 2021, which was the last updated. So it's been a few years, and I'll give you guys a little insider right now. When it comes to terms of service, typically a company will make an update when something happened. And they're like, oh my gosh, the situation happened. I don't want it to ever happen again. So I put it in the contract to safeguard the company. And we kind of made a point about this in our TuneCore video. And we're like, we set this big demand letter in regards to their terms of service and how unlawful they are and all this stuff on December 1st of last year, 2023. And then when we were looking at their terms of service, they had been updated on December, I think it was 13th. So like not too long after that. Interesting. In any case, we have not updated the terms of service here in a hot minute. Hey, maybe that's a good thing. This distribution agreement and terms of service here after the agreement is a binding legal agreement. We know that. This is a contract. By clicking to agree, you are accepting the terms. This is an enforceable contract, is what they're saying. DistroKid doesn't take any copyright or other interest in any of your music, only a limited license to distribute. So as we go through these terms, I'm just going to kind of, point out some of the stuff that I saw because I do this for clients. And they'll say, hey, I'm using this particular company. I am needing to do a certain thing. Can you just review these and point out to me anything that I really need to know? And so I've read a lot of terms of service and I know kind of what our hot points are and things that I want to point out. So you guys are the pretend clients today. All right, so in section 1, it goes through DistroKid services and your recording. So it does things like just define, what are the services? We're distributing your stuff to digital stores, recordings. What are the specifications? We need WAV files, we need MP3. So they're just going through, just kind of outlining how this whole thing works. 1, sub E is an egg. We will automatically generate unique identifying codes for each recording and provide them to your chosen digital stores. If you have a Music Plus or label account, you can choose to specify your own ISRC codes, but not UPC codes. Let me just explain that really fast. If that went over anyone's head right now, let's take a moment. What they're talking about is the ISRC number. The code is what is assigned to your song when you distribute through any distributor. So this applies regardless of where you're at right now, okay? And that code is really important because if for any reason you ever decide to move your music, you can retain all of the plays on music platforms. And you do that by re-uploading the music elsewhere after you take it off the current platform. You re-upload it and you put in the ISRC numbers, and then magically, all of your stuff has all the original plays on it. So some people will not know that, and then they lose all that good, will and all that time that they invested because they move the catalog. So kind of, my pro tip, please just try to make a note as you go along. It's hard to do it after you're like 10 years into this and you haven't noted any of these numbers anywhere. So, I have like a document, and when I release something new, I'll put in the name, I'll put in the ISRC number, and just like make it easy for yourself so it's in one place. So that's what they're talking about. Section 2, digital stores. Okay, so now they're talking about who are they distributing to. This stood out to me. They go, the rights granted by you to DistroKid are non-exclusive. All right, so on the, that was one. Typically with distributors, they do say that during the term of your agreement, you cannot put your music anywhere else. This matters because they just want to make sure that you're not like distributing it on CD Baby and then DistroKid and then wherever else. Because A, it creates problems for them, creates conflicts, but they also just like they're saying you're signing for a certain period of time. You're going to be with us during that time only. So this was one thing I was like, I kind of like that. But how does that work? Right? If it's not exclusive, are they saying you're cool to go and distribute your music on other platforms as well? Let's take a look. So let's see. However, if you do send the recording, so your music, to the same digital stores via DistroKid or a separate service, the double listing of your recordings may cause complications and or problems in those digital stores. So it looks like they're contemplating that. So it is non-exclusive. We kind of like that. But they are saying, obviously, if you distribute your music on 2 different platforms, you're probably going to cause issues. So just FYI. All right, digital stores. And so they go by further example, digital stores may offer your recordings for free or promotional or on a promotional basis. I wanted to point this out because they're basically saying like, if when you're clicking the buttons in your account and they go, where do you want to send your song? Where do you want to send your album? You click all the places that you want to send it. And so they go, just FYI, some of these places may end up putting your music up for free. They might do it on a promotional basis. So they are kind of putting that onto you because they're going like, look, we're not liable if they do some of these things, and they might. So that's why you should just pay attention to who you are sending your song to. I just want to put that out into the universe because stuff can happen. And so they're putting that responsibility on to you. And they're like, people might be able to listen and give free previews. And I know some clients do not like that. Like if they have not given authorization for the song to be heard prior to its release, for example, something to pay attention to. E, digital stores may choose not to carry one or more of your recordings at all or in certain territories, or to remove recordings at any time, per their policies and practices. All right, so I think this is one we're getting a little bit more into really what I'm looking for as far as what can DistroKid do related to your royalties? So we can't make any guarantees. We may also decline to distribute or may remove from digital stores one or more recordings from any and all digital stores. If we receive any legal claim regarding the particular recordings, if we reasonably believe that any legal claims or issues may arise. So basically, they're saying if we get a claim, again, this is something that we pointed out with TuneCore, we go, the language that says if we get a claim versus if something is proven. Because sometimes, and we're dealing with a case right now, literally about this, someone files a false claim. So in this, it is using more general language of if we get any claim, basically we reserve the right to take your stuff off of platforms. Let's go back. Okay, if a recording may violate the terms of service on any digital store for any reason in our business judgment. So if they have a business judgment and they think you're violating terms of Spotify because you're, let's say, copyright infringement, something like that, they can just take your music off. And if our agreement with any digital store expires or terminates, or if that digital store ceases to operate in its entirety, your recording will no longer be available through digital stores. Now, this isn't the end of the world. You know what I'm saying? It's important for me to point out to my clients when I'm like, just so you know, that is normal. Obviously, this is a contract that you guys are signing without any right to negotiate anything. You either take it or you leave it. If you want to use their service, this is what you are agreeing to. But something like that, where they go like, for example, if the DSP like no longer exists and we like take your music off of it because it no longer exists, there's stuff that they put in here that's very like boilerplate and normal. We aren't getting uppity about this, but that's why, we're pointing out anything having to do with their ability to take action against your music, to take action against your royalties, to retain your royalties. That's what we're looking for. All right, moving on. Section 3, your account. So they had been talking about your artist name, use of, during the term of the agreement, and basically in regards to payments of your membership, if, you need to request a refund. I did point this out that DistroKid has sole discretion, so they can decide in certain instances to refund you or not refund you. This one right here, you expressly authorize DistroKid to charge the applicable amount. Oh, and there's a great point I want to make with this. You authorize DistroKid to charge your account plus any taxes to the credit card you provide in its sole discretion to deduct that amount from monies payable by us to you. Any refunds are in DistroKid's sole discretion, once again. In addition, if you owe any fees or any amounts to DistroKid, we may deduct or set off such amounts from any current or future payments to you. So that's right there. This is the first place we're seeing where they give themselves the right to take from either the card that you have on file or to set off payments, meaning to take from your royalties, all right, in addition to our other rights and remedies. Now, the thing I would love to note about this, I had a lot of cover songs distributed through DistroKid for a while. And I opted in because at the time, this was before, the updates had been made in regards to just distributing your stuff and not needing to get mechanical licenses just for having your music on streaming platforms. This does not apply if you are having your stuff downloaded, if you're doing vinyls, if you're doing CDs. So I was paying for the mechanical license through DistroKid. Here's a little hack for you guys. If you need the mechanical license for any reason, you can go get it from a company like Harry Fox. I think I used them once. I use Easy Song Licensing. That's the company that I was using. So you go and get the license one time through Easy Song Licensing, for example, versus DistroKid. And I just would recommend that because what DistroKid is that they are regularly billing you for those cover songs. So after a while, I had a lot of cover songs and the bill added up. And it wasn't anything crazy too. It was like, at the time, like $5 a month, 5 times 12 times all the cover songs. It ends up being a lot more expensive than just getting the license one time. So that will save you a little money. I want to make sure to mention that. We're getting through this. So section 4, the term. So here's something that was kind of weird. So they go, the term of the agreement that you sign with them is 1 year. And I go, that's weird. Like, why do you even have a term in here? If this is non-exclusive, meaning I can go and put my music on other platforms, why does it matter? Well, just so you guys know, the 1 year automatically renews. And this is something that, just happens. So little pro tip on this. In most contracts, it usually just says it's going to auto renew. If you sign up and you sign a contract, you really should calendar it. So you can issue notice of termination if you want to not have it. But equally, it's not like you can't just take your music down and take it out of rotation. So I go, practically speaking, what are they saying here? Because if I take my music down at any point, which I can, but I can also have it up on CD Baby, it's not really like a term where I'm on your platform and I'm bound to you. So I'm actually saying that that's a good thing. For you guys who are distributing through DistroKid, you have a lot more freedom than I've read in other terms of service. All right, DistroKid may terminate the term for any reason. This is very common. All right, so these companies are always going to be like, look, the reasons you can terminate are usually very far and few. The reasons we can terminate will be just like we thought of it. And so we did. So I just wanted to point that out. But of course, they do give some listings. They're like, if there's issues, allegations, you're infringing intellectual property, the digital stores aren't accepting your stuff. And we've seen things even with TuneCore, that whole kind of saga. And I didn't cover this, but I know Tom McDonald, he had an issue with them as well because they didn't want to distribute one of his songs. And they were saying that because of the lyrical content, or he thought it was because of the lyrical content. I forget. But in any case, that, a store can just for basically any reason, just be like, I'm not going to distribute your stuff or I'm taking it down. Again, we're pointing out stuff of what's normal versus what's yikes. That's normal. All right, moving on. D as in dog. After the end of the term, we will notify all applicable digital stores to remove your recordings and will have no further obligation to you other than to account and pay for monies earned during the term. Okay, let me say something about that. We will have no further obligation to you other than to account and pay for the monies earned during the term. I love that. Because they're like, hey, for the stuff that we get after you terminate, the monies that come in, because if you guys remember, you usually get paid by quarter. Every platform is different, but typically, payments come in quarterly, it might be monthly. But in any case, they're like, after you terminate, there's going to be monies that still come in. And so we're going to give those to you. So I appreciate that because, again, in my TuneCore, just ongoing for multiple clients, and this is a different case than what I've been talking about on this platform, literally as of this morning. TuneCore came back because we are terminating the relationship with them. And I have not read this in their terms. I want to be clear. I've not read this in their terms. But what the TuneCore representative said is you are terminating. And so therefore, we're going to send you the payment and you are forfeiting all future royalties. And so now it's going to be another fight because we're terminating. There's going to be a lot more money that comes because this is a very popular artist and his stuff does really well and gets paid lots of money. And you're telling me we're just going to forfeit because we're leaving your platform. I digress. So for purposes of DistroKid, I wanted to point that out because that's good. They're saying that they are in fact going to pay you your royalties. All right, but we're not at the juicy stuff yet, okay? Because the juicy stuff is going to be what happens, can they forfeit royalties, what other languages here? So section 5, grant of rights. And here's the thing with these, it's like one sentence, but it's a giant run-on sentence. But what they do say here is that the right you're giving them is non-exclusive. We already covered that. And they can also sublicense and they can give those rights. And here's just a list. All right, so I just wanted to go through this briefly. The rights that you give to DistroKid, they can reproduce and distribute. We get that. That's the whole point of what they're doing. You give them the right to, authorize third parties and licensees to do additional things, right? So they're going to send your stuff, for example, to Facebook, to Instagram. Now, again, they're doing that at your authorization because you tell them what stores to send this to. But this is where these distributors just go great lengths. I mean, look at this, all right? They go to great lengths just to make sure that all the stuff that they are going to do for you is outlined because they want to protect themselves against claims. And I don't have a problem with that, okay? Because they're dealing with, tens of thousands, if not hundreds of thousands of situations, and artists, I should say. But this is where they just list it all out, okay? And there was nothing too concerning. This is all very normal. Additionally, and in no way limiting any rights granted by you here and above. You hereby grant to DistroKid a direct license to publicly perform your recordings, which solely for the purpose of clarity include the compositions on the DistroKid site, including without limitation, HyperFollow. So I actually looked this up. Let me just see if I can pull it up really fast for you guys. I was like, what's HyperFollow? Did they have this when I was on this platform? Why have I not seen it? A Music Attorney is your #1 legal resource for artists, producers, and record labels. Get contract templates, one-on-one legal advice, free master classes, and everything you need for your music business. Go to topmusicattorney.com. So this is HyperFollow. All your content in one place. HyperFollow is the easiest way to make pages that have your music, videos, social media links, and more for free. I haven't used this, but it looks like it's free. It looks like you can play the song. I don't know, looks kind of cool. So I just wanted to point it out. So they're saying in the terms, you give them the right to have your music on that. Section 6, you are solely responsible for and must have obtained all necessary rights, licenses, waivers, clearances, and permissions, including without limitation, all music publishing rights and licenses in order to distribute, reproduce, display, publicly perform, synchronize, and do all the things. Why do we care about this? Part of what we talk about on this channel is all the legal stuff, which is if you're going to do songs with people, you need to get something in writing. A skeleton version should be a split agreement. I give you a free one as part of my music business jumpstart guide program. It's free. Just go to topmusicattorney.com. But I give that to you so you can just write it down. Have something. And then the next step up from that is to do an actual collaboration agreement so that you just have it clarified that you own the stuff or you both own this stuff, who's going to get paid, how do you do it? And that is your protection, not just like from each other, but to have that clarification, but literally for things like this. If someone ever challenges you and they're like, he stole my song, she stole my song, if you can produce a contract, like, no, this is what we signed, here we go. Obviously, that's very powerful. And this is the house of cards that can come crashing down because in the your responsibilities realm, it's like you're promising you own this stuff. You have the right to distribute this stuff. And then, we look at, well, what are the bad things that are going to happen if it turns out that you're not and you get a claim and, all this stuff. So we're still in 6, but we're going down here now. So at the very bottom, I wanted to point this out because it goes, we do not, in caps, they're yelling. We do not and cannot provide you with legal advice regarding your obligations to third parties, so please consult a qualified lawyer before entering into this agreement and uploading any recordings to our services. The reason why they have this language and why you see it in a lot of the contracts that you will sign is because it makes it more enforceable. One of the arguments might be if you're like, oh my gosh, I didn't even know I agreed to this, or I'm a TuneCore person. Oh my gosh, I didn't know I was agreeing that I could, that you could take my royalties and I would forfeit my royalties if there was even just a claim. And so if you make the argument, I didn't know, that usually doesn't get you too far, but it certainly is powerful. If, for example, in the terms, it goes, hey, FYI, we're giving you an opportunity to seek legal counsel. Now, my problem with this in general is like, okay, again, I'm like, I would love to revise this section. They're going to ignore me. So no, you don't meaningfully have the ability to revise this, but that's why this language is in here. It goes, you had the opportunity to seek counsel, and by them doing that, it makes it more enforceable against you. So now we're at the juicy part. Section 7, payment and accounting terms. In full consideration of the rights and licenses granted here under, we will post to your DistroKid account 100% of any and all monies that we actually earn and receive in the United States, in the USA, from your selected digital stores. Great, love that. Which are directly attributable to their exploitation of your recordings after deducting PayPal fees, processing fees. 2, if you've opted into and registered for our separate mechanical licensing services. So guys, that's what I had kind of pointed out. I'm like, they're going to just pull the fee because it's a monthly thing, or at least it was when I was on the platform. We will also deduct the fee for services and all applicable royalties. We're also going to take a 20% for our content ID service if you opt into that. Okay, this is all, I don't have a problem with this so far. If DistroKid receives a lump sum payment from a digital store. This is where I had a little bit of a question mark. If DistroKid receives a lump sum payment from a digital store that is not attributable to any particular artist accounts. I don't know why that would happen. If anyone kind of has context of this, I'm curious. Or specific recordings from any particular artist account, DistroKid will, in its sole discretion, determine if and to what extent any portion of such monies shall be payable hereunder. Without limiting the immediately preceding sentence, DistroKid may determine to distribute such monies on a pro rata basis, so meaning they will equally distribute it based on the number of artists with whom DistroKid has distribution agreements. So they're saying we're just going to we're going to make it rain on everyone who's on our platform, okay? In its discretion amongst artists based on historical earnings and or proxy formula determined solely by DistroKid. Or 3, based upon the amount the digital store actually credits DistroKid for your recording subsequent to your payment. All right, so basically, they're like, we get a little extra cash and we don't know who it's payable to. Again, I don't know why this would happen. I would love an example. But they go, what we're going to do is we are going to spread the wealth. And this is kind of what Spotify has said. They're like, we're basically demonetizing, all you bottom feeders. They don't speak that rudely, but they're like, we're demonetizing everyone down here who doesn't get enough of the plays, the 1,000 threshold, and we're going to take those additional royalties and we're going to spread it out amongst everybody else. That's what they're saying. I guess I don't hate this. I have questions about this. All right, so let's keep cruising. We move down. We are still in section 7. All right, and then we get here. Any objection related to any accounting statements or any lawsuit arising therefrom must be made and or lawsuit commenced no later than 1 year after the date the statement is rendered, and you waive any longer statute of limitations that may be permitted by law. You shall have no right to inspect or audit our books and records or those digital stores. Why does this matter? This matters because in your contracts, when you see stuff like this, it goes, hey, in regards to the statements, because they give you statements. I don't know if you guys look at them. You should look at them. You should save them. But they go, hey, John, this quarter, this month, you made this amount. And it came from these songs, these platforms. Those are statements. And so if you don't look at them and a year lapses, what they're saying and what the contract that you signed by clicking says is that you waive any right to object to it later on. So this is problematic because you're just trying to do your thing and you're not paying attention, and a year goes by so quickly. And if you had an accounting question, you waived the right by doing nothing. So this is why it's important that you pay attention. And if you see something odd and stuff comes up and someone will be like, oh my gosh, I got 400,000 plays on a song and I didn't get paid for that. It's not showing it in my actual account. Stuff like that you want to look into, because what can happen is that you get barred. And that's what statute of limitations means. It means that you are barred from bringing a claim because of, in this case, contractual language that you agreed to. But we're not at the juiciest part yet. So scrolling down, they're just talking a lot about notifications, payments, nothing that really jumped out to me, but we get to G as in, oh my goodness. If we receive a claim or notice or otherwise reasonably suspect that any of your recordings or materials or the use of your site or service breach any agreement, infringe upon third-party rights, violates this agreement or any law, rule, or regulation, that there is a dispute regarding the recordings. Again, this is all stuff of we're fighting, doesn't mean that anything has been proven, okay? Including without limitation as to ownership or payment of monies. Going back to the whole, if you have a contract and someone is saying, John isn't the rightful owner. If you have a contract, you can be like, hey, DistroKid, here you go. And it can clear this stuff up and avoid issues. So I'm just saying it again. Or that your activities involve misrepresentation, misconduct, deception, fraud, or other inappropriate conduct. Now, what I don't like here, guys, is that these words are not defined. And we know they're not defined because they're in lowercase. So in the beginning of the contract, it had said this is your distribution agreement and terms of service, and then they use a capital A. That's called defining it. So every time we say agreement now, that's what it means because we defined it. So what I don't like so far is that they're like, if you are, doing things that we think are inappropriate conduct, what does that mean? So not loving that, but let's keep going. So if you do anything fraud or other inappropriate conduct, then in addition to any other available rights and remedies, we may suspend or terminate the distribution of your recordings and or the term of this agreement and or withhold payment of monies to you in an amount reasonably attributable in our discretion to such recordings. Okay, I don't hate that. In an amount reasonably attributable to in our discretion to such recordings, materials, and activity until and unless any and all claims and other conduct are favorably resolved to our reasonable satisfaction. Let's just take a beat. Again, in these contracts, that is very normal. So companies typically will just be like, look, if for some reason someone's like, he stole and he sampled and he all this stuff, like we still have to hire an attorney, respond, look at the letter, like we have to incur fees. And so what we do is we're like, everyone hold tight. We're not paying you out royalties because, quite frankly, maybe you did. We don't know. So it is normal for a company to say, we're going to hold tight. What we try to do as attorneys is when we see that language, we go, well, you can't just do it in perpetuity, meaning forever and ever and ever and ever, because sometimes these claims don't get resolved. Now, in here so far, I haven't seen anything saying if we don't hear anything in like 12 months and there's no lawsuit, we'll release your money to you. Doesn't say that. But so far, nothing too concerning. This is pretty normal. And so we can withhold some monies, we think is reasonable, and we may deduct from your payments and are related attorney's fees and legal costs in a connection. To the extent we're comparing now TuneCore, because we just took a big issue with the fact that they had provided a huge laundry list of basically everything under the sun. If there's any kind of claim of anything that they just say, we reserve the right to forfeit all of your royalties, and we can even give them to a third party. So far, they're like, we need to make sure if there's a problem, we might, withhold them for a time. They don't say how long, but we might withhold them for a time. And we may even deduct from your payments to pay our attorney's fees. So they're saying actual legitimate costs that they incur. I personally don't have a problem with that. For a company to be like, if we have to deal with this and there really is a claim and all this stuff is happening, it has to come out of your royalties. I think that's reasonable, but let's keep going. Last sentence. You will forfeit any monies that are attributable to your fraud, infringement, or other illegal activity. All right, so we just found it. You will forfeit. So they will keep any monies, any of your royalties that are attributable to your fraud, infringement, or illegal activity. Now, guys, let's zoom in. These are lowercase words. So once again, I just go back to my problem here is I don't think that a distributor under any circumstances should take your royalties. And in fact, I think the argument that you guys made that I liked was, if someone really is scamming, Spotify and they have fake streams and all this stuff, well, shouldn't the money go back to Spotify and then go back to the advertisers that paid Spotify? That's not how any of this actually works. But my problem here is that they go, you will forfeit any monies that are attributable to your fraud, lowercase, infringement, lowercase. What does that mean, infringement? If someone says that I infringed, if they said that I sampled, but what if I didn't? What if they're just saying? Or other illegal activity. What does that mean? So far, what we have seen is that there's actually stuff in here that we really like and that we think is reasonable, that's pretty industry standard, but don't love that. And that's something that I would definitely get into the weeds on if I was representing a client, and I have, in regards to, funds that were taken or otherwise, not paid, I should say, and then we were able to go and get them released to the client. So those are things that kind of stick out to me. So let me go back to this really fast. So Section 8, representations, warranties, indemnification. Just so you guys know, if you go down to B, I just want to point this out because you see this in contracts a lot. You shall indemnify and hold harmless DistroKid. And then it goes like all of our affiliates and attorneys and members and shareholders and all this stuff. Again, this is industry standard. This is common. When you do contracts, because right now you have zero negotiation power for this contract that you're signing, but generally speaking in contracts, you'll see that. It'll be like, basically you indemnify, you will pay attorney's fees. If it turns out that you really were sampling and you get us sued for some reason, you have to pay for it because we didn't do that. That was your bad stuff. So what you guys want to do as a pro tip is when you do have contracts that you can negotiate, you just make it mutual. You go, okay, cool. I indemnify you, but you indemnify me. Not that DistroKid would do something, but in another situation where the other side does something and they get you sued. So that's, again, what we do as lawyers. We want to make sure that you are protected just as much as the other company. No warranties, limitations of liability. This is other stuff that companies do. They go, this is as is. If bad stuff happens, this isn't our fault, and you can't, sue us for everything under the sun. So again, you are agreeing to this because you clicked, you accept the terms. So it does limit the liability. We don't like this. It's pretty common. These companies do everything they can because they get a lot of claims. All right, miscellaneous. This agreement, together with the privacy policy and our site, generally contains the entire understanding, and it supersedes, it overcomes, it is the thing that controls anything else. Again, just reiterating, this is a real contract that you have signed. DistroKid will not be liable for a curable breach of this agreement, guys. This is really important. Unless you provide us with written notice specifying the alleged breach that we confirm receipt of, and we fail to cure such breach within 90 days thereafter. Okay, so if they withhold royalties and, here you can send a demand letter yourself. You don't need an attorney. It helps to have an attorney, okay? But if you are going to notify them and you go, hey, you withheld my royalties and you're alleging that there was illegal activity, what does that mean? Like, you need to define that. You have to make sure you comply with what they say here, which is they're not going to be liable for anything unless you give them written notice. And you have to do that, and you have to give them 90 days, so 3 months to fix it. So you just, keep in mind procedurally, that's how you have to go about this. And then I'll even give you once more here, because people miss this for kind of just like self-help. So you have to send the letter, you have to give them 90 days, and then, looky here, this is where you send it. All notices to DistroKid shall be sent to legal@distrokid.com. They are absolutely going to hate me for pointing this out to you guys, because I want to help you. And I want to make it so that, hopefully you can self-help a little bit. But a lot of people don't know that this is where you find it. So you can put together your own demand letter, you can put together your own, information, updates, and you can send their legal department a notice in regards to their alleged breach. We reserve the right to modify, discontinue, or terminate the service, including distro lock, at any time without prior notice. We are also under no obligation to provide the service, including distro lock, continuously or at all. So again, just pointing out that they reserve rights all throughout this thing. This is normal for companies. They're like, look, if for any reason we don't like the way you do music, the way you do your art, we just don't like you, we can kick you off, and we're allowed to. And that was something that we pointed out with TuneCore. We're like, again, we were on a phone call with them and they literally called our client a scumbag. I go, you're within your rights. You are a private company. You can kick people off of your platform. Again, our problem here just has to do with the fact that we're talking about a middleman who's going to pass money back and forth, a glorified bank that artists have to go through, because you don't just get to upload your music onto Spotify. So that's why we're taking the time to look at these terms of service. And if you are distributed through DistroKid, I understand there's kind of two things happening here. There's kind of the experience of what it's like when you are literally using the platform. And I have heard a lot of really great things about, DistroKid. I had a generally very positive experience with them. The same kind of thing goes with TuneCore. And I'm like, even if you've had a great experience on TuneCore, that's not my issue today. My issue is with the four corners of the terms of service, what actually happened to our client, but also what you guys are being forced to sign to use one of these distributors. So we're taking a look. I hope you guys found this helpful. Make sure you leave a comment down below. We'll be back with another Dear Distributor of some type. And if you like this video, make sure you share it out.